which hasn't been taken yet, is in the names of Deputy Collins and Deputy Daly.
Yeah, this amendment, I think it's a very important amendment, and it's based on the European Part-Time Workers Directive of 2004 that this country hasn't implemented yet. And I noted the Minister earlier on was saying that she's not prepared to put into legislation directives that are not being passed by the EU. This has been since 2004, and I explain exactly what it proposes. It says, as far as possible, employers should give consideration to A, requests by workers to transfer from full-time to part-time work that becomes available in the establishment. B, requests by workers to transfer from part-time to full-time work or to increase their working time should the opportunity arise. And C, the provision of timely information on the availability of part-time and full-time positions in the establishment in order to facilitate transfers from full-time to part-time or vice versa. So essentially it means that if a worker was working 8 hours a week and resigns or moves away, that 8 hours goes up for the employees in the establishment, so they can either apply for that 8 hours to be added onto their, say, 12 hours, and vice versa. If somebody, for example, wanted to go down from 20 hours to 8 hours, in that case, that amount of hours comes available within the establishment, they can reduce their hours to 8 hours, and then that 20 hours would then go out to the workers in the establishment again, so someone can increase their hours. So I think it's part of the European Part-Time Work Directive, and I think we should seriously consider it.
Deputy Daly.
Yeah, I mean, it's really, this amendment is the reason why I'm sitting through here in committee this morning, because I think it's absolutely critically important, actually, and would be an enormous addition for so many people in the state who are presently actually underemployed. And I think the study on the prevalence of zero-hour contracts revealed the prevalence of part-time workers who were part-time, not out of choice. And, you know, when we look back and consider other payments that have been changed by the department, like the cuts to the one-parent family payment scheme, which was introduced by Joan Burton at the time, said, well, this was being done to encourage them to get more hours or to allow them to avail of more hours work rather than having the luxury of all that extra money they were getting on social welfare. But that's partly a different argument. But the point is, nobody has a legal right to access those extra hours and, if you like, fulfil that objective. And I think we should be doing that. It's far better. It's in line with the EU directive. It gives far greater security and enhancement. And, you know, we hear slogans about, you know, people getting up in the morning and all that sort of stuff, but it's not just a question of unemployment that pushes people into poverty. It's also low paid and inadequate hours and underemployment, and we do need to tackle it from the point of view of security of workers. And so in that context, an employer should be obliged to offer hours to a current worker who's seeking more hours in order to give that person access to more income if they need to, or should they wish to. And it is rewarding loyalty in that as well. It's not too onerous. And it's very much moved forward in the context of the likes of Dunnes Stores, where over 80% of the workforce were women. Many of them were the main earners in a family situation. They had a desire to get more hours, but they often couldn't get it. And particularly when that can be manipulated, if it's an employee who stands up for themselves or whatever. So I think it's key, actually.
Thank you, Deputy Daly. Deputy Brady.
Yeah, no, look, I fully support this amendment. I think it is a key amendment to the overall bill because, look, we've heard all of the evidence. I mean, we've heard the horror stories there from, you know, employees in Dunnes Stores particularly, and other employees working for employers. We know the difficulties there in terms of even accessing finance, going for loans. Mortgages are non-existent for a lot of the workers. So I think this is a key amendment. So certainly I will be fully supporting.
Thank you, Deputy Brady. Deputy Penrose.
I mean, any good employer would actually implement this. It wouldn't have to be part of legislation because we already have the existing corpus of employees there. And they know who they are and their work. And those extra hours are absolutely critical, as Deputy Brady says, for people who, you know, need additional hours to actually survive. Don't worry about mortgages or anything else, just to actually put bread on the table and probably get a lift, either a lift to work or get a drop of petrol to get to work. So this is a kind of a, you know, I mean, it's so obvious that one would anticipate that employers wouldn't have to be, shall we say, compelled or actually even think along the lines of doing something else. So I would hope that this is a reasonable thing, and it would be probably hard to police. Is the only thing that I find with employers, because I mean those large employers can construct all sorts of excuses as to why they're not doing something. But if they have work, surely somebody who is there already doing 15, 18, 20 hours, if there's an extra 5 or 6 hours, that could be absolutely critical to their well-being and to their economic capacity to earn some small of a livelihood. So I think that this Minister should be put into legislation, and it certainly would be. You spoke about, shall we say, guiding employers earlier on with the stake, and I think this might be just something similar, and it would be, I think, instructive as to how we view this matter from inside the Oireachtas here. As to what has been going on for a number of years.
Thank you, Deputy Penrose. Deputy O'D.
All the arguments that have been made already, but I mean, look, as I've said previously, what this bill, the category of workers that this bill will be protecting generally are people on lower pay. So I think, from that point of view, it seems to me that the amendment is eminently sensible, and I think that the legislation will be better followed, and I would be supportive of it.
Thank you, Deputy Minister.
I'd like to ask maybe Deputy Collins and Deputy Daly to withdraw the amendment and for us to meet tonight, tomorrow, as soon as we can, for one reason only. Deputy O'D has hit the nail on the head. This bill is specifically going to address issues that are being felt by people who are in precarious situations and particularly low-paid workers. But the outcome of the bill is going to actually affect every single worker in the country. And so what we're proposing to do here to fix an issue, and I totally agree it's an issue, will have an impact on the entire working population and probably could be overly onerous and restrictive in some people's businesses of being able to run their business. So could we meet and talk about how we could word it so as to address the specific issue that you're trying to address? In my head, logically, if you run a business and I had extra hours, rather than going out and employing somebody new and all of the costs and stuff that is associated with that, why wouldn't you just give the extra hours? But I know there's specific industries who are so mean-spirited, is probably the nicest way to put it, that they specifically don't. And I would like to be able to address that without penalising other businesses from being able to take on somebody extra, maybe with a different skill set that they might need if that kind of event occurs.
Thank you,
Minister. Can we have a look at the wording maybe just so that we can address the specific issue that you're trying to address without imposing, I suppose, restrictions on other businesses that don't, or who aren't mean-spirited, because this specific piece of amendment to the legislation would have an impact on every single employer as opposed to just the ones that you're trying to address.
Thank you, Minister. Deputy Collins and Daly, the question for you to decide at this stage is whether you want to go ahead and press the motion or whether you want to take the issue with the Minister after.
Well, we can choose to take different options, just so whatever either, No, look, I'd be inclined, I know I'm not a member of this committee normally, but I would be in these situations be inclined to sort of bag the result now. And if we wanted to tweak it later on and, work with the Minister in changing the wording for report stage, then that's would be another way of doing the same thing. So that would be my instinct. I think this is so important, I'd be inclined to sort of get it passed now, but absolutely meet you tomorrow or whenever to come up with something better, okay, if you feel
you're happy with
better.
that, Deputy Collins?
Yeah, I think that it's actually one of the key parts of this potential bill, and it is an EU directive since 2004. It's other countries have implemented it, and it's as part of their employment legislation. So I would be inclined to put it forward.
Okay. Section 15.
And
Yes.
again, maybe this will be teased out this morning, but it will reflect on how I vote now. How do you actually propose that it's going to be implemented? Is it going to be a notice stuck up in the notice board? How do I prove, as an employee, that I saw the note? How in practical terms is it going to work? And how then, in practical terms, that if you don't send me, or if I didn't see the notice for the extra hours on the wall, how are you going to enforce the employer So, like,
Deputy Brady, briefly, if you want to.
No, just very briefly, because I think the key word in the amendment is they have to offer and not give. You know, I mean, there's a distinct difference there. We're not forcing any employer. We're saying they must offer to give. If there is additional hours, they must offer those to part-time staff first, not give. Distinct difference there.
that's what I'm asking.
Well, how? Because that's actually what operates in most sensible employers would operate that system, because it benefits them as much as it does the employees. The purpose of putting it in law, though, is precisely those people who wouldn't be of a mind to do that, and who, let's be honest about it, have used this to victimise people who might be the most outspoken in employment and so on, and use it in a manipulative sense. So, in that sense, I think it's what happens in most areas. It's just talked about.
But what I'm asking is that how do they have to offer? Like, is it going to be something as ridiculous as sticking it up on the notice board, or are we going to, imply that employers have to write to all of their staff to say we have an extra 4 hours?
We don't prescribe how any employer carries out.
Then how are we going to make sure they do it?
Adhere to the law. Well, I mean, generally speaking, it's a provision that would be, I suppose, objected to if somebody had a problem with it. In most cases, if our boss comes in and asks the three of us, and I don't really care anyway, I'm not going to make a complaint about it, am I? So it would only, and the first time I'm not going to say, right, I'm going into the WRC, I'm sick of this. What I'd say is that, listen, John, come here, you're supposed to offer me the work, but you didn't. You brought your son in for a couple of hours. There's extra hours you're supposed to give him to me. I'm not going to, and then the next day he does it. It's about changing behaviour as well.
We've had the discussion. We've had the discussion. The point has been made. The motion is in order. The option to withdraw was offered and not accepted. So then it's my position that I have to put the amendment. So Section 15, Amendment 36, in the names of Deputy Collins and Daly, that the amendment be made. Those in favour? Those against? The amendment is carried.